All right, I think we'll start now. Um, Jess, is my internet stable?
Yes, you're good for now.
Okay. Apologies if run into any issues during the presentation today. Um, as I said, my name's Tyler Lefson. Sorry, Ebony, can you go to the next slide? My name's Tyler Lefson. I'm an attorney with Family Legal Care, and I'm joined by two colleagues today who I will let present or introduce themselves.
Good morning, everyone. My name is Jessica Stadmeyer. I am also one of our staff attorneys, and I'm also the Director of Legal Resources and Community Engagement at Family Legal Care. And Ebony?
Hey, good morning, everyone. I'm Ebony Morel. I'm the Community Engagement Manager here at Family Legal Care.
All right, thank you both. So I'm going to be presenting the bulk of the information today, but they are helping me with other parts of it and handling kind of some behind the scenes stuff. So a few, we're doing the poll already. So just a couple of housekeeping things before we get started. We really want this webinar to be interactive. So one idea of how to participate, put your name and introduce yourself in the chats. We'll be asking some polls like the one you see on the screen today or right now throughout the presentation to try to make it keep you guys involved. And if you have questions, put your questions in the Q&A and we will answer the questions at the end of the webinar. And then if there are any concerns you have throughout the webinar, feel free to chat with us and we'll try to resolve them. Next slide, Ebony. So the first poll for today is what brings you here today? What made you interested in learning more about child support for veterans? So a poll should have appeared on your screen and just choose the option that applies to you. Okay, Ebony, do we have the results? Yeah, okay, so we have a good mix of people. It looks like the majority of people are partners or advocates looking to help clients. So we also have some people who are parents or caregivers and just people who are interested in learning about this area of family law. So thank you so much for being with us to learn more about this topic. Next slide. So as I mentioned, we all work for Family Legal Care. I'm going to have Jess just do an overview of our organization so you have a better idea of what we do to help litigants in New York.
All right, thank you, Tyler. So before we get to the presentation, we just want to give a really brief overview of Family Legal Care in case you or someone you know could benefit from our services. So we're a nonprofit organization. We've been around over 25 years. You may have heard of us as LIFT, but last year we changed our name from LIFT to Family Legal Care. All of our services remain the same, and I'm going to briefly go over those. But our new name, Family Legal Care, we think really better conveys who we are, what we do, and the heart of our mission, which is to provide compassionate support and care to families going through New York State Family Court. All of Family Legal Care services are aimed at offering legal information and advice, as well as easy to access resources and technology to help unrepresented parents and caregivers navigate the family court system here in New York. And that's not just in New York City, but all over the state. And all of our services are completely free, regardless of income. Next slide. So here are a few highlights of our services. Our helpline is our main entry point to access our services. Our helpline associates can provide information about New York family law and family court procedure, as well as referrals and other resources. Our helpline is available by phone, email, and live chat, and generally is open from Monday through Friday from 9 to 5, though we do close down for lunch from 1 to 2. Our helpline associates are mostly bilingual, so we have associates speaking both English and Spanish, but we can assist other languages as well through an interpreter line. We also offer legal consultations through our staff and pro bono attorneys, and that includes myself and Tyler. Our attorneys meet with unrepresented parents and caregivers for 1-hour consultations, either by phone or video, depending on what you would prefer. And unrepresented means that you do not already have an attorney representing you in your case. Our consultations are limited scope, which means that our attorneys do not represent people in court, but we can give you legal advice and other assistance in your case, such as filing petitions or preparing for court. The level of support really depends on your needs and what's going on in your particular case. On our website, we offer additional resources and tools, including our guided court forms that walk you through completing different family court and forms and petitions in easy to understand language. And at the end, you get a PDF that's complete and ready to file with the court. We also have multilingual resource guides that provide step-by-step information on a range of New York family law topics. And we also have guides specific to military families, reservists, and veterans as well. Then we have our Family Law Navigator, which is a tool that allows you to answer questions about your situation and get a customized report with information and next steps. And then finally, we have an outreach program. So through this program, we partner with other organizations such as the vet centers to reach parents and caregivers who could use our services. And we also offer different events such as the webinar that you all are attending here today and other virtual and in-person presentations and workshops. And just to go back to our consultations, so next slide, please. It's important to reiterate that we do not have any income requirements for any of our services, and that includes our legal consultations. For a consultation, the only requirements are that you are not already represented by an attorney, that the case is one of the types of cases listed here, and that the case is in New York Family Court. So we provide consultations on paternity and parentage, child support, custody, visitation, and guardianship of minors. We can also advise people on domestic violence issues, such as how an order of protection impacts their custody case, but we do not provide advice solely on orders of protection. And we also do not provide advice on abuse and neglect proceedings, nor on divorce, which is handled in Supreme Court. And I'll pass it back to Tyler.
Thank you, Jess. So today, we're going to be covering just some basic information about child support in New York State that would be relevant to veterans. It'll include in the areas of modification, enforcement, and then as it applies to military retirement or veterans benefits. We'll also cover some resources that might be useful to someone dealing with child support issues in New York State. Next slide. Just a disclaimer off the bat, this presentation is just general legal information. It's not legal advice, any particular situation. Every case is different. If you would like advice in your case, please reach out to us and we can see about scheduling consultation, like Jess mentioned, to get you further assistance. Next slide. So to start, child support is generally going to operate the same way for veterans as it operates for other people in New York. But there are some particular laws that do make things a little bit different for veterans, or that they should be aware of when they are dealing with child support issues. And then also the reason why we're doing this presentation is because child support assistance is one of the top unmet civil legal needs for veterans or those who served in the military. And so we want to make sure this information gets out there, that veterans know that we exist to help them if they would need us. And so, yeah, hopefully this can be helpful in that way. Next slide. So some important terms. First, within child support law in New York State, there's the non-custodial parent. This is the parent who pays child support. They're the parent who does not have the child a majority of the time. This is as opposed to the custodial parent or caregiver. This is the person the child lives with most of the time, and they're the one who is entitled to receive support. You'll notice it says caregiver there as well. It doesn't have to be a parent. You can receive child support even if you're not a parent, if you're the one primarily taking care of the child. And the other term is legal parents. This means that this person has been officially designated as the parent of a child. And this is important because only a legal parent can be obligated to provide support for a child. Next slide. So child support is the financial support that the non-custodial parent provides to the custodial parent or caregiver to care for the child. And there's some various categories of support. First, there's basic support, which really is for general expenses like food, shelter, clothing, other small things that come up in caring for a child. The court can also include some other categories in the child support order, which would typically include addressing health insurance and unreimbursed healthcare costs, childcare expenses if those exist, and also education expenses. Sometimes the court can add other types of expenses into the order if the parties agree, but those are the main ones that the court will address on its own. Additionally, as I mentioned, the non-custodial parent pays the custodial caregiver. That can be paid directly to that custodial parent or caregiver, or it can be paid through the child support office. It's more common for it to go through the child support office, as there are some benefits to doing that, and I'll cover that later. If the custodial caregiver or parent is receiving public assistance, it has to go through the child support office because they need to keep track of how much is being paid, and they also will basically take a portion of that child support to reimburse itself for the public assistance they're providing to the custodial parent. Next slide. So just some questions that commonly come up. First, how long does a parent need to pay child support? You should know that in New York State, child support typically lasts until the child turns 21. At 21, they emancipate for child support purposes, and the non-custodial parent is no longer obligated to provide current support. If they have unpaid support, they have to continue paying that, and I'll talk about that more later. It is possible for a child to emancipate earlier. That can be if they get married, if they join the military, if they become financially independent from the parents. It also can go longer by agreement. So maybe the parties agreed to cover child support or college expenses until the child turns 22 or 23. Or a recent change in the law is if the child is developmentally disabled, it can go until 26. Next slide. A lot of litigants ask us, how long is my child support case going to take? It can take several months. It can take years to get a child support order. Unfortunately, the family court system, especially in New York City, is really backed up. They're having a hard time of really processing these cases quickly. So generally, you would expect to wait quite a while to get this over with. You should be able to resolve it with at least 2 hearings, but typically it's going to take more. Next slide. Litigants also ask us a lot, can I get an attorney in my child support case? Generally, you cannot get a court-appointed attorney. You don't have a right to a court-appointed attorney in a child support case unless you're at risk of being incarcerated for failing to pay child support. So in those cases, there's a liberty interest. And so the law is that you should get an attorney if you can't afford one. There also are not really any legal aid resources out there to provide representation in child support cases that I've found. In my office, we provide advice, and that's the most that I've seen as far as free legal services and child support cases generally. Next slide. And then just to talk about the general court procedure for child support cases. First, a petition will be filed. It can be filed to establish the initial order of child support, to modify an order, or to enforce an existing order. It can be filed by the custodial parent, the legal caregiver, the child in some cases, the state, if public assistance is involved, and also the non-custodial parent for modification purposes. And if both parties reside in New York, it's filed in the county where either party lives or where the child lives. The return of process, that's the first appearance in these child support cases. Generally, this is administrative. The court wants to make sure that the other party's been served. They then will discuss whether or not the parties want to hire counsel or proceed unrepresented, and then they'll schedule another court date. Sometimes they enter a temporary child support order at these hearings, but the courts are pretty inconsistent about doing so. Then third, you'll get to a fact-finding hearing or evidentiary hearing where the court will allow the parties to testify, present evidence. Sometimes this is kind of informal, where the court just kind of reviews the documents that the parties have submitted and asks questions of the parties, whereas other times you'll actually have formal testimony and cross-examination. It kind of varies. But after that, the court will typically take some time after that final hearing to issue an order. Next slide. So if both parties appeared during the case, that final order is going to be based on the evidence from both parties. Whereas if the respondent did not appear, it's just going to be based on what the respondent being the party who did not file the case. If they did not appear in the case, then it will just be based on the evidence of the person who filed. And this is called a default order. So this is when the other party doesn't appear in the case. This can be problematic, especially for non-custodial parents, because the court might base the order on amount of income that you don't actually make, and so maybe the child support order is too high. It doesn't reflect reality. So that's why it's very important to attend all your hearings. That way you can present accurate evidence, information for the court to base an order off of. It is possible to undo a default order. So if you have you have good cause as to why you missed the hearing, you might be able to vacate it or undo it, where they basically would reopen the case. Or if there was an issue with service, you might be able to vacate it due to bad or lack of service. If you didn't get the initial documents at the start of the case. The second term is garnishment. This is when your wages, money from your paycheck, is taken directly to pay child support. This happens after the initial order is entered. The income withholding order or garnishment order is issued by the child support office and is sent to the employer, and the employer then will withhold the money. This is the most common way that child support orders are enforced, but it can also cause a lot of problems for people when they're caught off guard by them, and it can also take a decent amount of money from your paycheck. Next slide. So regarding just the procedure surrounding child support, there's a federal law called the Service Member Civil Relief Act. There's a New York counterpart as well. It's mainly designed to protect service members who are dealing with civil legal issues. But the protections are for service members surrounding their active duty service. So it's possible that this could help veterans who are returning from active duty, because there's a window of time after the return where this law still applies, or if they decide to re-enlist, if they go back in to active duty service, it could apply. So what the protections offer would be that it could protect you from a default order. So if a case is filed, if a child support case is filed while you are serving active duty, your service is materially affecting your ability to participate in the case, the court should not enter a default order and should also vacate the default order if it later finds out that you were serving. You can also get a stay of proceedings. If the court finds out that you are actively serving, it should pause the proceedings. And then it can also stay garnishments, which means it could stop the garnishment from happening while you are serving or surrounding that active duty service. Next slide. So I want to talk about child support modifications for a while. This is in terms of what we help with when we help veterans or other people with child support issues. mainly helping them with modifications and enforcement issues. So really want to focus on modifications. So modification petition is used to ask the court to change the final child support order. To get the court to consider modifying the order, you first have to establish that there are grounds to modify, at least one ground to modify the order. There are 3 grounds. One is a substantial change of circumstances. The other 3 years have passed since the last order was made or changed. And 3 or third, either party's income has changed by at least 15%. So that can be up or down. If it is down, the decrease generally has to be involuntary. And I'll talk about that more in a little bit. Next slide. So the first ground, a substantial change in circumstance. This historically has been the ground to modify child support. The other 2 were added by law later, more recent amendment. And it's the most common reason to modify child support. But what counts as a substantial change in circumstance? Commonly, it could be that the child moved from one parent to the other parent, thus changing the custodial, non-custodial relationship. It could be that employment has changed. It could be the child is emancipated, as mentioned before, joining the military, getting married, child turning 21. Or it could be that the parent got incarcerated. Or change of employment, so where your income changes due to loss of employment, the court's going to want to know why you lost that job. They're going to want to distinguish between foreseeable, unforeseeable changes, voluntary, involuntary reasons. So if someone got fired for something they did, that's foreseeable and voluntary. The court's not going to likely treat that as a substantial change. Whereas if it was involuntary, the court would hopefully treat it as such. Next slide. So here's our second poll. Just to get you guys thinking about this. So the question is, which kind of change might the court modify an order for? So we have 2 scenarios here. First is Luis's. He's been paying Rosa child support on time since child support started. However, he recently got hurt on the job. His doctor says he will not be able to work for 6 to 7 weeks. Whereas with Erica, her job pays well. She just received the child support order from the court, but thinks it is too high. So then she decided to quit her job and find a job that pays less. Which person do you think is more deserving of a modification? Or who do you think the court would most likely modify the order for? So I'll give you just a little bit of time to think about that. Not a tough question, but. All right, Ebony, do we have the results? Okay, yes, thank you for participating. Yes, all of you said Luis would more likely be entitled to modification. Even Luis's situation, it's not guaranteed. It's hard to say sometimes what the court will do, but he has a better case for getting a modification since his reason was it was an accident. He was unable to go back to work due to something that was not his fault, whereas Erica's trying to dodge her child support obligation. Next slide. So if the court determines that there is a ground to modify child support, they will look at recalculating it. So typically they're going to base this off of the current income of the parties, as long as both of them provide evidence about their current financial situation. When they do this, there's a formula they follow. And I'm not going to lay out the entire formula, but kind of the simplification of it is that the non-custodial parent will pay a certain percentage of their income based on how many kids are subject to the order. So for example, 1 kid, it's 70%, 2 kids, it's 25%, and it goes on from there. If the court determines that formula amount is unjust or inappropriate, they can deviate from that amount and come up with a different number. They have to base it on other factors. So it can't just be like made up. It has to be rooted on some fact that came up in the case. Additionally, like I said, they based on current income, but if they determine that evidence is not credible or is insufficient, they can impute income, which means they would assign or attribute an income to somebody based on something else, like their work history, their education, earning potential, and if not that, then on the child's needs. So they have various ways of trying to come up with a number. So it's just important to be aware of that. Next slide. And then for veterans, this is something that's often asked about, but for the purposes of calculating child support, the court can use military pensions, retirement, and VA benefits based on disability for income. So like I said earlier, where they trying to figure out what your income is, those would be included sources for income. And I will talk about this later, but it's important to keep this separate in your mind from enforcement. So there are some exceptions for enforcement for these categories, especially or mainly the VA benefits, but I'll talk about that later. Next slide. So in terms of recalculating child support, the court needs evidence. And so what are some common types of evidence the court's going to want when calculating child support? The ones on the left are compulsory, meaning they're required by law. The financial disclosure affidavit, which lays out income and expenses, recent tax return, W-2 statements, recent paychecks. The ones on the right are ones that might be relevant. Letters of employment, odd jobs diary or job search diary. So if someone is working off the books or is unemployed and trying to find work, those would be relevant. For veterans, the VA disability benefits letter that says how much they're getting per month. A retiree account statement from the Department of Finance and Accounting Services with the military, basically laying out what your military benefit amount or your military retirement amount is per month. Next slide. So after all that, the court comes up with a final order of support. So they consider the evidence and testimony, and they will enter an order, basic child support, and like I said, maybe it'll cover add-on expenses as well. Generally, will cover health insurance and the basic support, maybe childcare and education. The modification order will typically go back to the filing date of the petition. So it's important to remember that because there'll be a retroactive amount that will be a separate amount from the new current obligation. So, and because there's already an order in place, the way the retroactive amount is calculated is that it will be, you'll subtract the amount paid during the case from that, the retroactive amount, and it will come with a net balance of what is left to pay. So if the modification is an upward modification, it might mean that you've underpaid during the case and therefore you have a balance. Whereas if the modification is a downward modification, it might mean that you've overpaid during the case and therefore you might be entitled to a credit. The problem with the credit is that it cannot be used to decrease your current obligation. It can only be used towards arrears or future add-on expenses. And then if either party disagrees with that order, the support magistrate abused their discretion, they got the law wrong, or they misapplied or they didn't consider facts that you thought were relevant or important, you can file what's called an objection, which is basically an appeal to the child support order. The objection has to be filed within 30 days if you received it in person, or 35 days from the date it's mailed if it was mailed. And then the court, a judge will review the objection as well as the underlying order and findings of fact, and will provide a decision at some point in the future. The amount of time it takes is also inconsistent. Next slide. So, and this is an important point for all litigants, but especially for veterans who maybe after returning from service, they lose track of the child support order. It's important to modify your child support order as soon as possible, as soon as something changes, because the court really has to follow that filing date rule, that they can only modify it back to the filing date. There are a few exceptions to that. So you would never want to count on those exceptions. So it's important to keep that in mind as a pretty firm rule. So in effect, the longer you wait to file, if you're the non-custodial parent, the more arrears you might owe. Arrears meaning unpaid child support. Next slide. So our next poll, so child support arrears go away when the child turns 21. So if you have unpaid child support, do they go away when your child turns 21? True or false? Right, Ebony, do we have the results? Okay, most people said false. We have one true. The correct answer is false. They do not go away. Arrears will follow you even after the child turns 21. They remain in outstanding debt that the custodial parent can try to enforce through court, or if the payments are made through the child support office, they will continue to try to collect on those amounts. As far as court goes, there's a statute of limitations for child support arrears of 20 years. So that may protect you from some enforcement down the road, but a long time down the road. And that statute can be reset in a couple ways. So it doesn't generally apply. Next slide. So let's talk about enforcement now and about unpaid child support or arrears. These are usually paid off a little bit at a time. Like I said earlier, garnishment is the most common method for enforcement. And so arrears will be tacked on to a garnishment order. They can collect up to 150% of what the current obligation was, assuming that the order is over. If there's still a current obligation, they can collect an extra 50% of that amount that would go towards the arrears. So how do you reduce your arrears? How do you get rid of them? If your case is in New York City and you have, or mainly it's if you have child support arrears to the Department of Social Services, meaning that the custodial parent got public assistance from the Department of Social Services in New York City, some of those arrears are owed to the Department of Social Services. And so it's possible that they could forgive some amount of arrears owed to them. However, otherwise, the arrears are going to be owed to the custodial parent or caregiver, and only they can forgive the arrears. So you may want to consider speaking to them about that or going to mediation. But ultimately, the way that would work is you would file a modification petition as long as they agree to forgive the arrears, and the court can enter an order basically eliminating those arrears upon agreements. Like I said earlier, there are a few exceptions to changing them other ways, but those aren't very common. Next slide. So how are arrears collected? It can be done through the child support offices spread out across the counties in New York State, or it can be done through a court case in family courts. Next slide. If the enforcement is done through the child support office, this is administrative enforcement. There's a list of things that they can do to the non-custodial parent to try to get the money from them or coerce them into paying the money. Here's just a few things. They can suspend their driver's license. They can put a hold on their passport so they can't renew it or get a passport. They can freeze a bank account and seize the money from the bank account. They can also intercept a tax refund and then put that money towards the arrears balance. There are ways to challenge some of these things. The child support office has forms to challenge them. So my office, we do help with those challenges sometimes. It might also be possible to kind of just talk with them and see if they would be willing to work something out. You never know. Next slide. Second is family court enforcement. Technically, you can also enforce it through in Supreme Court, but my office, we only deal with family court, and most of the enforcement happens in family court. So the government, if the arrears are owed to the government or the custodial caregiver, they can file an enforcement or violation petition family court. And so that would follow that court process that I discussed in the beginning about filing a petition and going through the whole process to enforce the order. What can the court do? There are a handful of things they can do, but the main things they'll do is they'll enter a money judgment, which is a statement about how much the arrears are. Money judgments carry a 9% interest rate on them. And so that's where people can get into situations where they might end up owing more than what the arrears are. And then second, or let me go back to money judgment. There are certain ways to collect on a money judgment, which I'm not going to get into here. Sometimes it can be difficult to get the money in the money judgment. So it's not like I think sometimes people think, oh, I got the money judgment, I've won, but there's a whole other process to actually get the money that's owed to you in the money judgment. And second, the court can hold what's called a willfulness hearing. So if the custodial caregiver parent asks for the non-custodial parent to go to jail for willfully failing to pay child support, meaning that they could pay, but they refused, the court can determine if the person should be incarcerated for up to 6 months. This is done by a magistrate. They can just make a recommendation. It then goes to a judge who confirms the order of incarceration. The 6 months can be served as a full 6 months. It could be broken up across weekends. It kind of is at the discretion of the court. The court will also typically set a purge amount. So they'll say, if you pay a substantial amount of the arrears, you will not have to go to jail. In the willfulness hearing, those are the cases where a non-custodial parent would be entitled to a court-appointed attorney if they can't afford one. Next slide. So in terms of enforcement, there's a couple laws that are applicable to veterans. First is about military retired pay. There's a federal law called the Uniform Services Former Spouse Protection Act, which allows the court to collect their military retired pay to pay child support. And this is just for a current or former spouse. So a lot of the military laws, they're specific about more protections to spouses than non-spouses. There is, however, a separate process for unmarried people to seek enforcement against the military retired pay. It would still go through the DFAS, which is the military office that handles garnishments, that basically payroll and garnishments for child support. Next slide. And then there's also Veterans Affairs, the disability benefits. So these generally are not garnishable; they are protected. So whereas they might be whereas they are considered income for calculating child support, they cannot be garnished for child support unless the veteran has given up or waived part of their military retirement to receive the VA disability benefits. And only that amount can be garnished. So there is an exception to where they could be garnished, where they're not protected. So if you are a veteran and you're being garnished for child support, it's important to ask that question. Is this garnishment proper? Did I waive my military retired pay to get the benefits? Next slide. And then this is not something that my office helps with, but it is closely related. So there is an administrative process through the VA called apportionment. So this is somewhat parallel to a state child support case. But as I mentioned, it's just within that agency. They basically review the situation and determine how much of the VA, of the veteran's benefits should be apportioned or withheld and go towards their dependent. So it's another way for someone who has a child and the other parent is the veteran, how they could go about getting some support from the veteran, or specifically from their benefits. So the issue comes up where, what if there's a state child support order and there's this apportionment process? Hopefully, the VA becomes aware of the child support order, that they're already being garnished, but a veteran should not be apportioned and also be garnished, where they're paying double for child support. This possibly could come up because they're really two different systems. It's the federal VA and the state level child support office and court system. Who can assist with apportionment? You could try reaching out to the Veteran Advocacy Project if you're a veteran. They might be able to help you with that process if it's started by the other parent against you. The Veteran Advocacy Project also assists with other issues that veterans experience. So you might reach out to them if you need other assistance too. Next slide. And then I just want to talk about interstate child support a little bit. I mean, generally child support cases are everybody lives in New York and the order is from New York. But this might come up where one of the parties lives outside of New York, or they move out of New York, or maybe the order is from another state other than New York. There is an interstate child support unit within each county that's within the child support office, or a person who can help custodial caregivers with interstate issues. So if you're in that situation, you can reach out to them and see if they can help you. Sometimes they will file petitions on your behalf or assist in getting a case started in another state if that's appropriate. So generally, the state that entered the original order is going to keep jurisdiction for child support purposes, for modification, unless both parties have left that state. So let's say the order is from New York, but everybody's left New York. A modification will be started in the state where the other party lives. So because that state would have jurisdiction over the other party, or authority to enter an order over the other party regarding child support. And then further, there are certain laws of the state that started or that entered the original order that will follow the order. So even if it's modified in a different state, they will have to apply the law of New York, the original state that entered the order, in regard to certain issues, like how long child support goes for. So in New York, it goes until 21. So they would have to apply that same duration in a modification. Next slide. Now, I just wanted to cover some resources that might be helpful to you all, and I touched on already, but just to be more explicit about them. Next slide. So there's the Division of Child Support Enforcement. That's the statewide office. There are the local support collection units in every county. They help parents and caregivers with child support. They can mainly help people who are trying to get child support, but they can also help people who are paying child support sometimes with challenging the administrative actions, doing an audit of the account to make sure that the number is right. They might also be able to work out other arrangements with them, like payment plans. Here's the contact information. Contact your local county's child support office. Their hotline is 888-208-4485. Next slide. There also may be a mediation service in your area that provides free mediation services, or maybe one where you have to pay, but they could possibly help you work out an agreement with the other parents regarding child support issues, even if it's trying to work out an agreement about modification or decreasing the arrears. If you worked out an agreement with a mediator, you could include that with a petition to modify, and that would make it clear to the court what you're wanting, and should make the case resolve a lot more quickly. The court still has to review the agreement and make sure that it's one that it wants to enter. But generally, the court's going to approve the agreements. Here are some mediation providers that we're aware of. There's NILAG. Their phone number is 212-613-5000. There's the Center for and these are in New York City. There might be other mediation providers outside of New York City that we're not aware of. If you have questions about that, we could try to help you find a place. There's a Center for Mediation Training, 212-799-4302. There's a New York Peace Institute for people who are in Brooklyn and Manhattan. Phone number there is 212-577-1740. Your local child support office might also be aware of other options. Next slide. And I'll now pass it off back to Jess to partially wrap it up.
All right, thanks, Tyler. So that's the end of our formal portion of the webinar, and we're going to open it up to questions now. So if you do have questions, but you haven't submitted them yet, you can submit them in the Q&A feature at the very bottom of your screen, or you can also put them in the chat. So we'll just give everyone a couple of minutes to enter any questions. And then in the meantime, we wanted to give everyone a reminder of how you can get in touch with us, whether you have follow-up questions from today's presentation, or if you need some support with your case, or maybe you have a client that could use our services. So you can reach out to our helpline, and that number again is 212-343-1122. You can visit our website at familylegalcare.org, and you can follow us on social media. And next slide, please. So before we get to any questions, if there are any, we would also love to hear back from you and get feedback on today's webinar. So the feedback form is listed here on this slide, but we're also going to put the link in the chat. So we would love to hear how we did, maybe topics that you'd like to see next time, or any suggestions on how we can improve this webinar. And if you'd like a copy of today's slides, just make sure to enter your email address, and then we'll be sure to send them to you in the next week or two. And now I'm going to pass it over to Evany to see if we have any questions that were submitted.
Thank you, Jess. We haven't received any questions yet at the moment.
Looks like we actually got one in the chat just now.
Okay. All right. So someone asked what they can do regarding a situation when they were getting a divorce and they couldn't have their son 50-50. They currently have their son less than one night a week, and they are looking to get 50-50 or see if they could get away with child support, or do away with child support.
Okay, here, let me look at it myself. Savings. Oh, okay, I see. Yeah. Okay, so this is a divorce. The first off, with the divorce, you want to make sure that the judgment allows for the family court to modify custody visitation and child support. Typically they do, but it's important that it has concurrent jurisdiction or authority to do so. Otherwise, only the Supreme Court can modify. You would, if the other parent is not allowing 50-50, or if you don't actually have 50-50 or more yet, then it sounds like you could try to modify custody visitation first, and then you could try modifying child support. Something I didn't mention, which I meant to, if you do get a 50-50 schedule, so if it is actually 50-50, the court will designate the paying parent, the non-custodial parent, to be the person who makes more money. So, which can be confusing to people. New York is not a state that enters $0 orders when it's a 50-50 schedule. They still designate someone to be a paying parent, and whoever is the higher paying parent, or sorry, whoever has a higher income is the paying parent. They can deviate from that, but ultimately that's up to the magistrate to decide. So just because you get, I guess what I'm trying to say is just because you get it, just if you do get 50-50, you're not guaranteed to end child support.
And I'll just add to Tyler, I know that today's presentation wasn't about custody and visitation, but just a brief overview of what would happen if you do want to modify a custody order or parenting time arrangement. So in order to modify something that's already been made a final order, you would have to show the court that there's been some sort of major change in circumstances or substantial change in circumstances. And then you would also have to show the court how that modification that you are requesting. So in other words, if you're requesting 50-50 parenting time, how the 50-50 arrangement would be in your child's best interests. And then if you are successful in getting that modification, like Tyler said, then you can go and try to modify the order for child support.
And I'll say too, it's also just real quick, like let's say you got 50-50 without modifying custody visitation, and just in reality, you have your child half the time. The child support court or the child support case is not beholden or dependent on what the custody visitation order says. They could find that you are the custodial parent in the child support case, and you're, even though you're the non-custodial parent in the custody order. So it's in some cases modification of custody visitation isn't necessary. But anyway, Ebony.
Yes, thank you, Tyler and Jess. If you could also explain the difference between an allocated order versus non-allocated orders.
Allocate. Can you provide more clarification? Allocated.
So perhaps while we wait for the person that asked the question to give some
if
more
you could clarify
information.
about the allocated, if that was something that you heard me say, or is something that you've heard. I'm not familiar with allocated.
If we can move on to the next question then. Someone asked if the same applies to police officers or firefighters. Are their benefits also protected?
So in this, those laws I mentioned were just in regard to service members. There's a separate law called ERISA, ERISA, which basically requires there be a particular order entered to garnish like a pension fund for child support purposes. It's called a QDRO, a Qualified Domestic Relations Order. So some pension plans they follow this law, and they may have their own form QDRO, or they may say you need to make your own, or the custodial parent needs to make their own to actually get access to the pension funds. But that's so that the pension can actually send the money to the custodial parent. Once the money is sent to you, if the money's in your account, it's vulnerable to like that enforcement mechanism I mentioned earlier, where they can freeze your account and take the money from there. So I'm not aware of any other particular protections for police officers or firefighters.
And I can go back and try to answer the question about the allocated orders. So we don't actually see them too often, which is why we're not, super familiar with them. But my understanding with an allocated order is if there are multiple children that the child support is supposed to be intended for, then an allocated order could say that a certain amount goes to one child, a certain amount goes to the other child. And then if one of the child ages out or turns 21, the order is automatically reduced by that amount that had been allocated towards that child, versus a non-allocated order where the non-custodial parent would have to actively go and file a petition to remove the child that turns 21. But I actually haven't seen that too often. I don't know, Tyler, if you've ever seen that either.
Yeah, I've seen it. It happens sometimes. Yeah, I haven't heard it referred to as allocated. But yeah, I see that sometimes, and it can be confusing for people because they think that their order is going to automatically decrease once the oldest child emancipates, but it doesn't. You could have an order for 3 kids, but 2 of the kids are emancipated. So you're paying or receiving support for 3 kids when there's only really 1 kid that's eligible. And so that's why, again, it's really important to modify the order as soon as or shortly before that substantial change happens.
Mm-hmm. Right. And we tell people to keep an eye on your order. So if you're a non-custodial parent, keep an eye on the amount, because if it is an allocated order, you might see that amount reduced. But if it's not, then you want to make sure you're going to modify and take off any children that have turned 21.
you both. We received another question. So, can my son's mother take me to court if he is 20 years old?
Sorry, Ebony, can you repeat that again?
Yes. Can my son's mother take me to court if he is 20 years old?
Yeah, it's he hasn't turned 21 yet, so she could potentially seek child support for the last year of for this last year that he's eligible to receive support.
There aren't any other questions coming in at the moment.
Okay, we'll give it a few seconds. All right. Well, if we don't have any other questions, I just want to say thank you so much for sticking with us and listening to our presentation. We hope it was helpful. And really, if you want to talk to us further about this information, want more specific information about what we covered, or if you're someone who you think could benefit from legal advice from my office, please reach out to us. But please share your feedback. If you want the slides, let us know. But just again, thank you so much for your time. With that, have a good day.